because this is what is interpreted by the Honorable Apex Court. When a marriage has been dissolved, I'm sorry, Mother, just talk over it. Section 15. When a marriage has been dissolved by a decree of divorce, which is done here, and either there is no right of appeal, where this is a right of appeal in favor of my learned friend client, against the decree, or if there is such a right of appeal, the time for appealing has expired without an appeal having been presented, or an appeal has been presented but has been dismissed, it shall be lawful for either a party to marry again. So, my lord, this period is not over. My learned friend appeal is within time. So, my lord, the marriage, according to this, should not have been done, but it is done. Now, what is the effect, my lord, that lordship may come to judgment, my lord. This section helps, my lord, my learned friend.
Now, this judgment.
Yes, my lord. Now, lordship may come to the paragraph 30 onwards, my lord, 3 paragraphs, where, my lord, what my lord Justice Bobde has said, my lord, in a separate judgment, supporting but supplementing judgment. Last page, my lord, last but one page.
Para 15.
Paragraphs 30, 31 and 32. I am in the agreement with the view taken by Nageshwar Rao J, but it is necessary to state how the question before us has already been settled by the decision of Leela Gupta, that is earlier well-known judgment, even when the words of the proviso were found to be prohibitory in clear negative terms. It shall not be lawful, etc. This court has held that the incapacity to marry imposed by the proviso did not lead to an inference of nullity. This may be marked. While paragraph 9 of Leela Gupta, it is all more difficult to infer nullity when there is no prohibition, where there are no negative words, but on the other hand, positive words like it shall be lawful. Assuming that a marriage contracted before it became lawful, to do so was unlawful, and the words created disability, it is not possible to infer a nullity or a voidness by the paragraph 9 and 10 of Leela Gupta. The court must have regard to the consequences of such an interpretation on children who might have been conceived or born during the period of disability. The observations in Leela Gupta are wide. They are undoubtedly made in the context of the proviso of section 15 of the Hindu Marriage Amendment Act 1976, which I have read, since deleted, the proviso open with the prohibition that it shall not be lawful. This court considered the question whether a marriage contracted in violation of the proviso would be a nullity or void, and came to be the conclusion that though that the proviso is couched in prohibitory and in negative language, in the absence of an express provision, it was not possible to infer nullity in respect of a marriage contracted by a person under the incapacity of the prescribed by the proviso. What is held is essence is that a provision of law, the prescribes in the incapacity to marry, and yet the person marries. Now this is what I am relying upon, and yet the person marries while under that incapacity, because in this case this has happened. The marriage would not be void in absence of any express provision to that declared nullity. Because the incapacity imposed by the statute, there is no difference between an incapacity imposed by the negative language, such as it shall not be lawful, or an incapacity imposed by the positive language, like it shall be lawful, in creation a condition in the absence of which is in the implied unlawful. It would now, this is the important line, it would thus appear that the law is already settled by this court that a marriage contracted during a prescribed period will not be void because it was a contracted under an incapacity. Obviously, this would have no bearing on the other conditions of a valid marriage. The decision in Leela Gupta's case thus covers the present case of law. So, my lord, my marriage at present cannot be said lawful, but it's not a void. Because today Lordship, as far as appeal is concerned, as I understand, admitted. If it is not admitted, also it may be admitted. I cannot raise a first appeal. It's for Lordship prerogative. But as far as CA is concerned, in this given situation, now there is no eventuality which remains where the Lordship can call upon to pass any order restraining me for marrying. Because I already married. My marriage for this period till appeal is decided, suppose it decided in my favor, that my marriage which is already it will become the legal marriage. Suppose it is decided against me, then this marriage will remain as unlawful. The case was because
Where the first appeal was over.
yes, ma'am.
In this case, the first appeal pending
So that's
was
true.
dismissed and over. Here, even while before the first appeal is filed, you married.
Yes, my lord. During that period, my lord, whether first appeal is filed or not filed. Well, in this case before in the Supreme Court, first appeal was pending and marriage took place, my lord, during pendency of it. During the second marriage.